Good day everyone. In this video, I will be discussing the case study of the Smith-Kline-Beckham Corporation and Trico Pharma Corporation. Also on how the law of patents can be applied in this case study. Smith-Kline-Beckham Corporation, the petitioner, a corporation existing by the virtue of the laws of State of Pennsylvania, United States of America, and licensed to do business in the Philippines. The company applied for a patent over an invention entitled Methods and Composition for Producing Biphasic Parasiticide Activity Using Methyl 5-Propythionine 2-Benzimidazole Carbamate. The application bore serial number 18989. On September 24, 1981, Latter's patent number 14561 for the invention was issued to Smith-Kline-Beckham Corporation for a term of 17 years. According to the claims of the Latter's patent, the patented invention consisted of a new compound named methyl 5-propythionine 2-benzimidazole carbamate and methods or compositions utilizing the compound as an active ingredient in fighting infections caused by gastrointestinal parasites and lungworms in animals such as swine, sheep, cattle, goats, horses, and even pet animals. In the meantime, Trico Pharma Corporation, the private respondent, is a domestic company that manufactures, distributes, and sells veterinary products such as Imprigon. Imprigon is a drug that has albendazole for its active ingredient and is claimed to be effective against gastrointestinal roundworms, lungworms, tapeworms, and fluke infestation in carabaos, cattle, and goats. As a result, Smith-Kline-Beckham Corporation filed a patent infringement and unfair competition lawsuit against Trico Pharma Corporation. It claimed that its patent covers or includes the substance albendazole, and that Trico Pharma Corporation violated its patent by manufacturing, selling, using, and causing the drug Imprigon to be sold and used without its authorization. Trico Pharma Corporation responds by stating the patent does not cover the substance albendazole because the word appears nowhere in it. That even if the patent did cover albendazole, the substance is unpatentable. The Bureau of Food and Drug permitted it to manufacture and market the Imprigon with albendazole as known ingredient. As a result, the latter patent number 14561 is null and void. Smith-Kline-Beckham Corporation appealed to the Court of Appeals, but it was denied. Smith-Kline-Beckham Corporation's evidence fails to explain how albendazole is identical to methyl 5-propythionine 2-benzimidazole carbamate in every essential details. Apart from the fact that albendazole, like methyl 5-propythionine 2-benzimidazole carbamate, is an anthelmintic agent. Nothing else is asserted or justified regarding the method or means by which albendazole weeds out parasites in animals, leaving no information on whether that method is considerably the same. Finally, Dr. Orion's testimony does not support Smith-Kline-Beckham Corporation's case because he was not qualified as an expert witness with knowledge or expertise in the field of chemical compound. According to the Law of Patent Provision, Section 7, any invention of a new useful machine shall be patentable. Section 9, an invention shall be considered new or capable of being patented if it was known or used by others in the Philippines before the invention thereof by the inventor named in an application for patent for the invention. Section 15. Provided the application in this country is filed within 12 months from the earliest date on which any such foreign application was filed, and a translation thereof to English, if not in English language, is filed within 6 months from the date of filing in the Philippines, unless the Director for good cause shown shall extend the time for filing such certified copy. Section 46. If the court shall find the patent or any claims thereof invalid, the director shall, on the certification of the judgment to the office, issue an order cancelling the patent or claims found invalid, and shall publish a notice thereof in the official gazette.
The Meade-Johnson case. In a 1963 decision, the Supreme Court of the Philippines ruled in favor of Meade-Johnson and Company in its petition against NVJ Vanderp Limited. Vanderp had filed an application for the registration of trademark Alaska. Mead Johnson opposed the application on the grounds that its trademark Alacta would be damaged because the two marks were confusingly similar. In answer to the opposition, the applicant alleged that its trademark and product Alaska are entirely different from oppositor's trademark and product, since applicant's product cover milk, milk product, dairy product, and infant food, which fall under Class 47, foods and ingredients of foods, while oppositor's product covers pharmaceutical preparations for nutritional needs, which fall under Class 6, which refers to medicines in pharmaceutical preparations. After hearing both parties, the director of the Patent Office ruled in favor of Vander and dismissed the opposition. Mead Johnson appealed this decision, arguing that the director of the Patent Office had erred in his findings. The Supreme Court agreed with Mead Johnson and found that the trademark Alaska sought to be registered by Vanderps was confusingly similar. In conclusion, the court ruled that Vanderp's application for registration of its trademark was rejected. The court ordered the director of the Patent Office to cancel the publication of Vanderp's trademark and to take steps to prevent its registration.
The provisions of the law on trademarks, as stated in the article The Ethics and Law for Online Organizations lecture series, include the prohibition of false designations of origin and false or misleading descriptions or representations. It is unlawful for any person to use any word, term, name, symbol, or device that is likely to cause confusion, mistake, or deception regarding the affiliation, connection, or association of the person with another person, or regarding the origin, sponsorship, or approval of the person's goods, services, or commercial activities. The law also prohibits the misrepresentation of the nature, characteristics, qualities, or geographic origin of goods, services, or commercial activities in commercial advertising or promotion. So, based on this case study, these are some of the possible provisions of the law on trademarks. Number 1, the requirement for a trademark to be registered with the Patent Office in order to be protected. Number 2, the prohibition of trademarks that are confusingly similar to existing registered trademarks. Number 3, the requirement for a trademark to be distinctive in order to be eligible for registration. Number 4, the provision for opposition to the registration of a trademark by interested parties. Number 5, the provision for a hearing and decision by the Director of the Patent Office on disputes regarding the registration of trademarks.
Good day, everyone. I am Vincent Junmar de Ibero. I will be presenting the case of Francisco Joaquin versus Franklin Leon on January 28, 1999. The owner of Certificate of Copyright number M922 BGPI is the petitioner BG Productions Incorporated Roda and Me, a dating game program that's shown from 1970 to 1977, dated January 28, 1971. On June 28, 1973, petitioner BGPI submitted an update to its copyright certificate to the National Library detailing the format and presentation style of the show. Following the petitioner's complaint, information for PD number 49 violation was filed against the private respondents, ZUSA, and a few RPN 9 officer for airing its date. It was given to RTC Quezon City's Branch 104. Before the Department of Justice, ZUSA asked for a review of the Assistant City Prosecutor's decision. Respondent's Secretary of Justice Franklin M. Drilon overturned the Assistant City Prosecutor's conclusion on August 12, 1992 and instructed him to file a motion to dismiss the case against private respondents. Joaquin, the petitioner, submitted a move for reconsideration but it was rejected. The court decided that the show's format is not protected by the copyright. The classes of works that are eligible for copyright protections are listed in Section 2 of PD number 49, often known as the Decree on Intellectual Property. The clause is nearly identical to Section 172 of the Philippine Intellectual Property Code, or RA 8293. The list of protected works in Section 2 of PD number 49 does not contain the structure or mechanics of television program. Because of this, the law's protections cannot be expanded include them. In the strictest sense, copyright is only a legal obligation. It is not only an already existing right that the statute regulates. Rather, it is a new autonomous right that the statute grants. Being a legislative grant, the rights are only those that the statute confers, and they can only be attained and enjoyed in relation to the things and people and under the circumstances laid out in the statute. The court holds that as they fall under the category of works described in PD 49, audiovisual recording of each episodes of Rhoda and Me are protected by petitioner's BGPI's copyright. The dating game show's format or overall concept are not protected by the copyright. The two dating game shows' broad formats cannot be adequately described in the words alone. The master videotape was presented as evidence, which was crucial in determining if there was a probable cause. A television program comprised more than words can convey because it incorporates a wide range of visual and oral elements. As a result, only a comparing the general copyright and formats of the two game show will not reveal any similarities or differences. And that's all for the presentation. Thank you.
The applicable provision under the copyright law, Section 2 of the Presidential Decree number 49. The creator or his heirs or assigns shall own the copyright in any of the works mentioned in Section 2 of this decree. If the works is produced by two or more persons, the copyright shall belong to them jointly and the respective rights thereto shall be governed by the rules of the Civil Code of Co-ownership.